Are you vicariously liable for your employee or an independent contractor you employ? What is vicarious liability? Note 3 points. 1. Vicarious liability means you are liable for the wrongdoing of someone else. Second, for it to work between two parties, the old law was one of them must be an employee. You cannot escape vicarious liability. It is a very strict law. Let me give you some examples. Suppose you are the owner of a carpet cleaning company. Your employees are well trained, but one employee damages a customer's Persian carpet. As his employer, you are vicariously liable for your customer's claim that you are not at fault, that you are not at the scene is irrelevant. Suppose if your employee steals the Persian carpet, you are still liable. Again, if after work, an employee on the way home while driving the company car injures someone, you as the employer are liable. So much for employees. Now, it used to be that an employer was not liable if a non-employee is the wrongdoer. Then the law changed. The law is constantly on the move. First, strict vicarious liability was extended from an employee to a fraudulent agent. Then it was further extended to a wrong done by any agent. Take, for example, a religious institution. Is it liable for the abuse of children? Some Catholic priests had sexually abused boys under their care, but they were not strictly the institute's employees. Could the religious institute be sued for damages? Under the old vicarious liability rule, the case would have failed. So, were the institution and the priests liable? The UK Supreme Court developed a new principle to deal with this terrible situation. It ruled that vicarious liability was even applicable to anyone whose duties were akin to employment, like employment. So, although the priests were not employees, the institution was vicariously liable to the students. This applies to religious institutions and schools, whether public or private. What happens if an independent contractor messes up? Now take the Persian carpet example above. Suppose you ask an independent contractor, not an employee, an independent contractor to clean the carpet. And suppose the independent contractor damages the carpet. Are you liable? If the customer sues you, you can ask the independent contractor to pay over the damages to the client. The old law was, if the independent contractor makes a mistake, he must cover your loss. In these carpet examples, you are not personally responsible to the customer for the act of cleaning the carpet. Cannot outsource certain responsibilities, however, to third parties. The law requires that some duties are so important that you cannot outsource them to third-party contractors. These include the responsibility assumed by schools and hospitals. Suppose you're a carpet cleaning company or school or private clinic or hospital. Your job requires you to pay personal attention to the work you're doing. You cannot get rid of your responsibility by delegating its performance to someone else. No matter to whom you hand over the duties, you have to keep a personal eye on the job, whether that person is a servant or an independent contractor. If something goes wrong, the courts do not go after the independent contractor. They hold you as employer or the person responsible for the independent contractor to be personally liable. So watch your back. Goodbye.